Welcome to the Undisciplined podcast reading series. There's an introductory video explaining everything that this series is about, why we're doing it, which books we're going to read, how it's structured. So now this is the first substantive episode, first release of Hans Kelsen's A Pure Theory of Law, Chapter 1. We're going to do a video for each chapter. This is the first one. The chapter is called Law and Nature. So what the idea is that I'll discuss slowly what is going on in this chapter, my reading of it, which I think is perhaps a little bit different in emphasis from the standard reading that you probably got in your undergraduate philosophy of law course. But yes, why A Pure Theory of Law? This is really the book that stands as the kind of monument, in my opinion, of the positivist movement in legal theory. It's a work that, if we talk about modern or 20th century legal philosophy, I think we cannot get around this one. We have to go through it. It's also in our series chronologically the first one, and I think that's why we do it first, is so that we can see how it influenced the books that came subsequently. The book A Pure Theory of Law, the first edition, came out in German in 1934, but in 1960 Kelsen released a much more expanded, much revised, much more thorough version, which was released 7 years later, 1967, in English translation by Max Knight. And this is the version that we're reading here. So this chapter, Kelsen lays down a lot of the groundwork, a lot of definitional work being done, a lot of distinctions being drawn, and some of them kept, some of them discarded. Kind of the things you would expect the first chapter to have going forward into the rest of the book. He gives his justification for his choices, his methodological choices that he makes. So the title of the book already gives away a big part of Kelsen's idea, namely a pure theory of law. What does a pure theory imply? What is purity in this sense? So Kelsen has a problem with the prior study of legal theory in that he says law is often studied through the lens of other disciplines, at least when we're doing theory building. He names politics, sociology, economy, and he says that's all good and well, and these fields have something useful to say, and that there are insights to be gained from it, but a pure legal theory cannot get mixed up with the methodologies of other disciplines. So in order to avoid methodological confusion, a pure theory of law should use legal methods, legal reasoning, not reasoning from other disciplines, in order to arrive at its conclusions. This is also why he says in the very first sentence, he says this is a positive theory of law. So a positive theory of law means that it uses legal methods, and the object of the study, what this methodology is applied to, is law. Law is our object. So what does that mean? Kelsen says that what we're studying in the broadest sense are acts. And he distinguishes immediately between two different kinds of acts. He says acts that can be perceived by the senses, the normal, he calls these subjective acts. These are always human acts, by the way, not the non-human or the natural world. Law is strictly a human or social endeavor. So we have acts, subjective, perceivable by the senses, and then on the other hand, we have objective legal acts. These two can overlap, of course, but where subjective acts are from the observing position of perhaps a single person, objective legal acts are acts that are observed from the point of view of the legal system, and legal meaning is projected and received onto those acts. So this is what he places as the fundamental object of a pure theory of law. Which begs the question, how do we know the difference between a subjective act and an objective legal act? He says that we arrive at this answer through interpretation. Fair enough, but what do we interpret through? We need a lens when we're observing and interpreting. Kelsen's answer to that is that we interpret acts through norms. And norms, this is the key word for him. Now again, this begs another question. What is a norm? A norm is an act or behavior which is commanded, permitted, or authorized. And he quickly admits that society is full of commands, not just legal or normative commands. We're always commanding in every day. So he juxtaposes a legal command or a legal norm with the command of a gangster. I like to picture a highwayman who stops you on the highway and says your money or your life, which is a form of command, right? An everyday kind of command. Why is that not a legal act? Why does that contravene the law and it's not a legal command? He puts this in opposition to the income tax collector, who also comes to you and says your money or something else, imprisonment or whatever. What distinguishes these two? Kelsen says that the gangster does not have a norm behind him. The government tax collector has a norm behind him. So it's the norm that distinguishes these commands. So norms often command, but not all commands are norms. So how do norms come about? One of the ways which Kelsen provides us is a very traditional account of norms, and that is namely through custom. So we know what custom is. So two persons or two groups or communities act towards each other in a certain way. And through their action and through their mental exercise, a norm is created, an expectation and a norm is created. Even after the original people involved in this process have passed away, we see the norm still existing. So norms that emerge this way have an independent life or existence outside of the individuals that make them. You know, we could say it's not pure contract, but something bigger than that, something more permanent, these kind of norms. But how do we recognize a norm? That's how it comes about, but how do we measure the normness or normworthiness of something? So Kelsen gives quite a few requirements of what a norm should have. He calls this the effectivity of norms as one sense of that. And how do we know that a norm is effective? He gives at least two reasons. He says, firstly, norms are applied by legal organs, and that it is also generally obeyed by subjects to that legal system. Laws can be personally valid, they can be materially valid, materially being not applicable to persons, but applicable within the sphere of human activity, such as politics, economy, etc. Norms can also be valid in a limited sense or unlimited sense, for all time and for everyone, or in a limited time for a limited amount of people, or even though or even just one person. So quickly, the idea of values come up in the chapter. So in applying norms, a decision has to be made. Kelsen talks here about values, and he says the only value that we can use if we want to approach law and norms in a scientific or positivistic or pure way is the negative and positive value attached to non-compliance and compliance of a norm. So those are the only values that a real scientific lawyer should concern himself with. Has a norm been followed? That's a plus. Has a norm not been followed? That's a negative. These are the only values that we're capable of judging norms and laws. So in this sense, the values of the legal system are not inherent, but they're completely arbitrary, and they are projected from outside of the legal system, right? So we cannot say, legally speaking, whether a certain law is of high or low value. This has to come from outside the law. All the legal system can say is the law has been complied with or it's not been complied with. This is the only positive and negative values known from within the legal system. This also has important implications for legal judgment. Let's say the judge in a court, right? He's not projecting his own values, hopefully. We know that's a problematic statement. Ideally speaking, or scientifically speaking, if you like, what does a judge do? He only, at the end of the day, even after hearing arguments and saying that there are different interpretations of the law, he only has to decide, has a norm been complied with or not? And if it's been complied with, it's fine. Not, then there's sanction that follows, punishment that follows. So this is important because it means that this decision, this value-free value of the legal system, compliance, non-compliance, it's a simple, factual question. It's not about good or bad, or good or evil, or right or wrong. It's simply judgment. Legal judgment is a conclusion that can be reached rationally through the application of an intellectual process. In this sense, judgments are neutral. We should all be able to agree, ideally, on what a judge decides, because we just refer back to the law system, to the norms. That's all. Whether it's good or bad is a different topic. It's not a topic. It's a topic for ethicists, not for lawyers. So what this also means is that law is a social order. It's an order because it structures human behavior, but it's social because it's completely socially constructed in this sense. Think about it. If we don't have values referencing outside of the legal system, it means it's a social order. Humans made all of this. Morals, religions, these also qualify as social orders. We can distinguish this from natural orders, such as the example that Kelsen uses is logic. Logic has norms. There are certain things that are logical and true and logically false. This does not originate or emerge strictly from the human mind. This is found outside in nature, outside of the social, unlike the law of morals, completely social. So this brings us to sanctions. A norm has to be sanctioned. So he distinguishes here between two kinds of sanctions. He talks about transcendental sanctions. This is again outside of society. A transcendental sanction means the justification for the punishment comes from morals or from religion or some idea of nature or our terrible pop cultural understanding of karma. On the other hand, we have socially immanent sanctions. These originate completely within human society. So legal sanctions, it's not, when you go to prison, it's not God punishing you, it's not nature punishing you, it's society punishing you. So the legal system has no values outside of its own compliance or not, and its sanctions find their justification from within the legal system, nowhere else. In this sense, moral sanctions are also socially immanent, according to Kelsen, because moral disapproval is a social construct. It's not natural. So at this point, this is where I want to diverge a bit from the typical reading of Kelsen. Because, you know, Kelsen's name is very often equated totally with his idea of the Grundnorm, the basic norm, from which all norms, as they refer infinitely back to each other, that chain is broken by introducing the Grundnorm, the basic norm that justifies everything that follows from that. You know, this is a typical kind of solution to a problem. If we have a paradox, where does this law get its justification? From that law, from that law, from that law. And eventually you have this paradox where you can infinitely regress. And one way to break a paradox like that is to appeal to a value higher than, hierarchically higher than the level on which you're operating at that moment. And Kelsen does that by referring to the Grundnorm, which is the norm that kind of breaks open this infinite loop and puts a, you know, the buck stops there. And this is what he's been famous for, but I don't think this is the key here for me in this chapter. What I think is more interesting, and which I think is he spends way more time talking about, at least in chapter 1, is the coercive nature of legal sanction. So as we know, sanctions can exist in society in a moral sense, taboos or being shunned from society, polite society, breaking of etiquette, you don't get invited to parties perhaps. This also happens when you study legal positivism. But for Kelsen, coercion does not exist in those kind of sanctions. It is only in the law that we find real coercive sanctioning, violence. So how did this arise? He starts from a very Hobbesian starting point, saying that violence was widespread and anyone could enact violence on others, and that this was a threat to social security. So in order to increase security, mutual security within a society, violence had to be taken out of the hands of most people and centralized and monopolized in one place. And in this way, the average man becomes less and less violent for his own security. Until all this violence is monopolized in one organ, namely the state. Some forms of personal violence have remained, such as, well, blood feuds are gone, but took much longer than other forms. Self-defense is still allowed in many cases. So not all violence has been monopolized, but the vast majority of it. At this point, Kelsen brings up St. Augustine, who asks the question, what's the difference between the threats and violence of a robber gang compared to the threats and violence of a state? But no, seriously, what's the difference? And Augustine's answer to this was that the state has justice on its side, the robber gang doesn't. For Kelsen, as you might intuit, this is not a satisfactory answer. Firstly, justice is a transcendental value. Kelsen is not sure what justice is, so he says that cannot be the difference. So what is the difference between the state and a gang? He gives a few answers to this, none of which satisfy me entirely. He says in the first case that when a robber gang threatens you to do something, they threaten you with violence, give your money or else. That or else is a command saying that violence will be inflicted. Whereas in the legal system, the sanctioning norm is an ought to. It's not a promise of direct violence. This is not entirely satisfying to me. Secondly, he says that the legal system's sanction is backed by a Grundnorm, the robber gang's not. Again, it's a kind of a circular argument to me. But he would say the point is that the legal system or the state has a Grundnorm behind it. Finally, and this one I buy the most, but also not completely, he says that the advantage that the legal system has in its sanctions, its coercion, is this idea of objectivity over subjectivity. In other words, that legal sanctions and coercion is applied and decided upon by a judge who's impartial and objective to your certain case. He doesn't stand anything to gain directly, I guess. And the point is that he judges, as we said, through a rational process of applying existing norms. He doesn't have skin in the game. He's just going by this positive negative value inherent in the legal system. On the other hand, Kelsen goes on to say that a robber gang, which can be stable enough, can control the territory long enough, can protect itself from external threats, and that its internal threats and norms are being basically effectively followed by the people living there, that such a gang could graduate to the point of a state. Although he never actually says that directly. He uses the example of pirate states in the past to say that they were state-like, but not completely states. Which, I mean, this again begs the question, at what point does a robber gang become a state for Kelsen? I'm not sure. Maybe we'll see it in later chapters, although I doubt it. So, finally, I think the point that I'm trying to emphasize here is that rather than the Grundnorm, the aspect of coercion seems much more important in this first chapter for Kelsen. He also gives his reasons for this. He says in the first place that it's coercive sanctions that distinguishes the legal order from other orders, from moral orders, religious orders, whatever. So coercion is a defining feature of the law. The second point is that it's through this coercion, this monopoly on violence, that we can make a direct and strong link between the law and the state. In Kelsen's definition of the law, the state is essential and coercion, violence, is essential. Anyway, that's it for chapter 1. I'm looking forward to doing chapter 2 next. Just to finish off with, here is a list of a lot of the kind of binary distinctions that Kelsen draws in this chapter. Maybe it's a nice guide if you're reading it by yourself to keep that next to you and refer back and forth between that to see exactly kind of these branching distinctions that he keeps making in this chapter, laying out the definitions and the work and the assumptions that we're going to deal with in the future. So, thank you very much, and have a lovely day, and I'll see you next week. Thank you. Welcome to the Undisciplined Reading Series. It's me, Niku, and We're still doing Kelsen's A Pure Theory of Law, and today we're talking about Chapter 2, Law and Morality, Law and Morals. So we saw in the first chapter that Kelsen separates the science of law as the science of norms, as opposed to the natural science, right? Or nature. He makes this distinction between law and the natural sciences. And then he also makes a distinction between law and morality. So the moral still being a social system of norms, but that it's different from the legal system. This is important for Kelsen. For a legal theory to be pure, it has to be separated from the natural sciences, and it has to be separated from ethics or morality. And in this chapter, he goes in deeper detail exactly what the difference between legal norms are and moral norms are, and why it's important for a legal theory to keep these two separate. So we know from the first chapter that Kelsen definitely recognizes some overlap or similarity between law and morality. They're norms. He says they regulate both internal behavior, thought processes, or behavior that affects only an individual, as well as external behavior that affects other people or society in the bigger sense. He says both law and morality regulate how people act in accordance with or counter to their own inclinations. You know, you're more likely to follow a rule, hopefully, than not to follow it. I think a kind of a Luhmannian way to phrase this would be to say that both systems of norms attempt to make certain patterns of behavior more probable. There's also a similarity between law and morality and how they are formed, their norms. Both are formed by the will of the individuals, as well as a kind of a custom. You know, we saw that law arises through custom, but morality too. It's always has a past, it's a history, it's how we do things, right? So they're also similar in how they come about. So then the question becomes apparent. So if they're both norms that try to regulate individual behavior and make certain acts more probable or patterns more probable, what are their differences? One difference is that Kelsen says that the legal order is usually centralized, where the moral order is not. It's dispersed across society. There isn't one body that enforces morality, right? As opposed to the law. He says very primitive forms of law operate in this way, but not modern law. With the exception, perhaps, he says, of public international law. And that's why he says it wouldn't be completely wrong to call international law international morals instead, because international law does not fit within the centralized element of his definition of law, of a legal system. I mean, that's debatable, right? It's a question, is he interpreting the facts to fit his theory? Perhaps a little bit, I think. But nevertheless, it is what it is. You can make up your own mind about that. A more important difference between law and morality is not in what they command or what they do, but in how they do it. Importantly, this means that morality, the how of morality, how it enforces itself, is through social approval or disapproval. You have esteem or disesteem in society. Law, on the other hand, as we saw in chapter 1, works with coercion. it's easy to imagine there are many laws that you can break that does not affect your esteem in society. It might even increase it if you break the law under certain conditions. But law enforces itself through coercion, through violence. That's its mechanism. So we see clearly that Kelsen makes a hard distinction between law and morality. And he says that we should not confuse these two. It causes conceptual problems. So then the question becomes, what should, or what is, in his opinion, the relationship between law and morality then? Despite their shared form, normative form, their content and their method is different. So why, for Kelsen, is it important to distinguish law and morality? He says that what's important is, and we said in chapter 1, we referred to the transcendental, but morality can never have a claim to universality. Law theoretically could, although in practice we know we have different jurisdictions, and law is willing to border itself within that and at least claim a universality within those borders. But morality tends not to do that. And the problem is, if we start making legal judgment based on morality, the question very quickly becomes, whose morality? The law we can point to. Morality is too relative. It is, for Kelsen, not a scientifically hard enough object, I think, to make that the basis of judgment or the basis of law, legal judgment. He tries to find an example of a value, a moral value that would count as universal. And, he can't even find that. The closest he gets is perhaps peace is a universal value. But then he says, but no, history, the modern society is full of examples of people who did not hold peace to be the highest value. There are situations in which violence would be justified, although peace would be something to strive for. It's not ultimate, it's not universal. He uses the example from the quote from Jesus, who says that I did not come to the world to bring peace, I came here to bring division. I come here to bring the sword, I come here to bring war between father and son. That's also a favorite quote of Zizek. So he says it's not obvious that peace is a universal value. So in this sense, because of the relativity of morals, it is scientifically meaningless to say that the law ought to be moral. We would never agree on that anyway. So, as you can guess, this means that morals are not a factor in whether a law or a legal norm is valid or not. But he qualifies this. He says that this does not mean that the law and its norms fall outside of what he calls the good. That law should still strive towards the good. But if we put it in this more specific sense of morality or ethics, it's too subjective to meaningfully strive towards that. And then I think an important nuance here that is not always represented well enough, I think, is this distinction between, if we talk about kind of the law from the inside, if I can put it that way. And then the law is observed from outside by the legal theorist or the legal scientist, not the practitioner who creates and interprets law, but the one who looks at the whole system, which is sort of what we're doing here and what Kelsen did. Obviously, Kelsen has this strong drive to be objective, scientific, empirical, which, you know, that's open for a whole bag of critique by itself, but let's put that to the side for now. But he says that if we study the law academically from the outside, it's not the purpose of the legal theorist or the legal scientist to approve or disapprove of a particular law. The purpose is to describe it, right? There shouldn't be a value judgment in a purely descriptive exercise meant for understanding the system better. And through the internal logic of the law, a law remains valid only by its own metrics. Measuring it from the outside against morals cannot invalidate a law. The immorality of a law cannot invalidate it. We're comparing different criteria. We're comparing apples and oranges here. And then Kelsen justifies this, or he goes further by sort of dabbling within the ethical, trying to make ethical arguments for separating law and morality. He says, out of a kind of a political point of view, he says it seems that the laws of one's own country always seem to be moral to you, while the laws of another country seem to be immoral to you. And that should already signal to you that something is amiss and points to the relativity of law. So insisting that laws have to be moral or immoral justifies, in some cases, justifies intervention in a foreign country. Think of how human rights have been instrumentalized in that way. You know, we're going to intervene in another country because they're not applying human rights law. They're not going about with the law in a moral way. And thus we have a legal justification to attack them. Also, the value of peace being put to the side there. So he says that moralizing over the law can be dangerous. It can have immoral effects. And secondly, he says that by insisting on the morality of the legal system, it makes one uncritical of the legal system that you're living under. If you assume that it's morally justifiable, you are subscribing to this coercive natural order. And there's a danger in that. Having a pure positivistic theory of the law makes you able to see the law for what it is, and you can then, without arguing over whether it's valid or invalid, you can be more critical about it, accepting that it's valid and do something about that, rather than this uncritical acceptance of this violently imposed normative order. So that's basically it for this chapter. It's quite a short one. I think it's the shortest one in the book, so this video is also a bit shorter, but it's also interesting because this idea, apart from the Grundnorm thing, this positivist idea that law and morality is separate, we see that he does not pay that much attention. The next chapter on law and science is actually significantly longer, that we'll do in the next video. But I think it's important not to be too reductive about this law and morality relationship in positivism or in Kelsen. I think it's a little bit more subtle, a little bit more nuanced. I think it's easy to say that law and morality should not be mixed up. But I think what people perhaps miss sometimes is that we're not talking about separating it from only within the legal system, whether you're a lawyer or a judge or a legislator, whatever, and that it gives you carte blanche to be immoral. That's not the point. What is more important or more interesting here is keeping in mind that Kelsen is writing this as an academic who takes the scientific rigor of what he's doing very seriously and is trying to make a cold, pure, scientific theory of law. And that morality is not a scientific enough concept for him in describing law, and that this is not, the split between law and morality is not only within the legal system, but it's from this outside position that Kelsen is doing it from where the split becomes important. So from the second order observation, if I can put it that way. And I think within the framework of what he's writing and what he's trying to do in his way of thinking, it makes sense. The point is that we can, of course, also do our second order observation of what Kelsen is doing and criticize his assumptions, which hopefully we'll get to later. But anyway, that's chapter 2 of A Pure Theory of Law. Next video we'll be doing chapter 3, which deals with law and science. Thank you. I hope this was helpful and have a nice day. Hello, it's Nico here. Today we're talking about chapter 3 of Kelsen's A Pure Theory of Law. We saw in the first chapter, Kelsen laid the groundwork for where he goes with his theory. In the second chapter, he got to what is often most talked about when we talk about positivist legal theories. It talks about law and morality, and we saw in quite a fairly short chapter, right? He doesn't spend that much time making his case there. But now in the third chapter, it's a significantly longer chapter than the second one. He talks about law and science. So I'm assuming that this is for Kelsen a more important distinction and a more important topic than that of law or morality, or at least a question that is more complex, perhaps, that requires more clarification. I think it's interesting that he spends this much time on law and science rather than law and morality, right? It seems to be a greater concern for him. So we know from chapter 1 that he says that the science of law is concerned with the law manifested through norms applied to human acts. He says, okay, legal acts that are relevant to the law. Again, he starts with a distinction. He talks about a static theory of law and a dynamic theory of law. One at rest, one in motion. A static theory of law, according to Kelsen, is one that focuses on the behavior that is regulated by norms. We could say the acts. A dynamic theory is one that focuses on the norms themselves that are regulating acts. Like we said in the previous chapter, that are making certain human acts more probable than others. So in a static theory, the object of study would be the system of valid norms. In a dynamic theory, the object is the process of how these norms are developed and being applied. So not just this corpus of a system of norms, but how it's changing dynamically. Kelsen has an interesting quote early in the chapter where he says that it is a most significant peculiarity of law that it regulates its own creation and application. Today, I would call that, or at least since the 1980s, we could call that the autopoiesis of the law, or the self-reference of the law. But, okay, Kelsen didn't have that word at his disposal, but he's already recognizing this self-creating nature of the legal system, this kind of closed or semi-closed loop that it's perpetuating itself in. And he says what's also worth noting is that law doesn't only have norms that apply externally to itself, to society, or to human beings, but that it also has norms that apply to itself. For example, how to interpret, how to create a new law, how to get rid of a law. So the law has law for itself. This is what Kelsen calls the rules of law, not to be confused with the rule of law. So he tries to answer how this happens. How does this self-regulating, self-perpetuating system with its own secondary rules of law come into being? And he goes back all the way to Kant for this. He says that using the epistemology of Kant, that the law creates its own object through observing itself as a whole, meaning that the law or the legal system sees different things happening in society and sees them as related and pulls them together under this category that it calls law. And it sees a whole or a system there. He says this is a purely epistemological move. These connections are not obvious in a certain sense, but they're constructed socially, right? Much like looking at the chaos that surrounds us and calling that nature, for example. You know, just as nature has been invented by society, so the singular coherence of the law has been created by society. And the purpose of legal science, as we know by now, is not in prescribing it, drawing on morals or whatever, utility, I don't know. It only has the purpose of describing the legal system. This is what legal science has to do. Description. And we have descriptions of the law everywhere. He says, you know, the law is, for example, the penal code, and a description of that is your criminal law textbook. So you have first order and second order observation there already. So anyway, returning to natural science, Kelsen puts the natural sciences and the social sciences at odds with each other. And law falls within the category of the social sciences. So he says that natural science works through causality. If A, then B happens. Or if you have B, then you know A was behind it. These are the laws of nature, so to speak. And he says that human behavior and human society can also be linked through causality, right? The social sciences and the natural sciences are perhaps not that different. He says that causality is always there. But the social sciences law has a second quality apart from causation, namely imputation. So if you have A and B, you can connect A and B through causation or through imputation, which I think you can already get a sense that it implies a human decision being made, a projection and a decision linking these two things. But a difference between these links, if causation or natural sciences says A, then B, what the law does, it doesn't use then. It uses ought. If A, B ought to happen. So the connection between A and B is different. A norm is not a scientific or natural law that B has to logically follow A. It's a command, an ought to. And sometimes B doesn't happen. And that's where validity comes into play. How valid is that norm really if it doesn't happen every single time? It's not a causal link. It's a description that connects A and B that make it socially logical for B to follow A. If you commit a crime, A, you don't blink your eyes and suddenly you're in prison, B, right? There's a lot that has to happen in between. It's not a direct causal connection. It may look like it, but it's not. It's imputed. There's a lot of social things that have to happen in between, a lot of communication that has to happen in between A and B. And it ought to happen, but it's not taken for granted. Kelsen goes on an interesting detour in this chapter 2, again talking about primitive man. I don't like the term, but let's take it within the historical context that Kelsen was writing this in. But he says that primitive man probably did not, he's speculating here, of course, but he says that it did not explain nature through causality, but rather through imputation. What does this mean? It means that when something happened in nature, let's say a natural disaster of some sort, humans at that time didn't have natural causal laws to explain why that happened the way we would now, but they would impute a value, a judgment on the disaster happening, right? So if your town was hit by a disaster, the question wasn't what happened, what caused this. The question was who caused this? What did we do wrong to cause this? There's a sense of moral value judgment taking place. You know, the idea that nature is punishing you somehow. He connects this with the idea of animism or animistic religions, the idea that nature and humans have this relationship kind of like what people have in between them, where if you treat nature badly, it comes to take revenge on you or something like that, or the spirits, they take revenge on you. And he says if anything was a breakthrough in the scientific revolution or the Enlightenment, it was the invention of causality, moving from imputation to causation. And then through this, he makes a kind of a funny observation. He says that it's not that we had nature and later society was invented, but that the whole world, including nature, was society first. Relationships governed, linked through norms and imputation, and that with science, the natural world was invented. Nature was discovered through causality. When causality was discovered, nature came to the fore. And Kelsen is aware enough that he says that causation is also not taken that seriously within the philosophy of science, even when he wrote this book already. You know, that science does not work on strict laws, but that probability is what governs natural relationships, if I can call it that. So using this term causation the whole time is fine, as long as we keep in mind that this is already something linked more to probability than certainty. On another detour, he also takes some time to criticize American realism, the realist school of legal theory. And he says that The problem is with American realism is that it tries to somehow predict court decisions. And he criticizes this because he says, it's taking the past and the future A and B and trying to connect it with causality. And he says that, no, it's not causality, it's still an imputation. The court decision is still an ought to. It's not a natural consequence. And I think, although I don't think he says that explicitly, he probably would also, if we remember chapter 1, he would also, I suppose, criticize American realists for confusing a pure theory of law with political or sociological theories of law. So while a realist approach can have some power, descriptive or predictive power, it's not rooted within the law itself. It's rooted in other disciplines. So, in this distinction between causation and imputation, Kelsen also says that another important difference between them, and which is necessary for the law to work, causation never has an endpoint, right? We know that. You have A, then B, then C, then D. The physical world is always dynamic, always having domino effects forever. There's no endpoint to causation. Whereas with imputation, on the other hand, there has to be a logical end. Or you can't, to take it in the other direction, you can't regress infinitely. When we blame someone, you can always pass the buck to something else. With imputation, that chain has to stop somewhere. The buck has to stop somewhere, and someone has to take responsibility. And this, Kelsen says, by the way, is the definition of freedom. It's, yes, being able to do what you want, but the responsibility of being the last instance of imputation. You have the responsibility for that, and you have to take the legal sanction or whatever. Finally, Kelsen ends the chapter by defending his pure theory again. He says that he's been accused of being ideological in his theory. And he says that no, he is the anti-ideologue. He says it is anti-ideological exactly for the reason that he rejects any ideal or correct or right or moral law. And he is the one that can see law for what it is. And his critics are maybe referring to some immanent value, transcendental value, and they are the ideologues, not him. He's the scientist. And he is not trying to prescribe any existing or hypothetical future social order. He's not interested in doing that. He is just doing the careful scientist's work of describing reality as he sees it around him. But yes, that's it for chapter 3, Law and Science. I hope that was quite a big chapter. I hope it made it a bit simpler to digest. Thank you, and see you next time for chapter 5. Hi, welcome to the Kelsen reading series. We're doing chapter 4 today. The static aspect of law is the name of the chapter. So this is quite a meaty chapter, and immediately from the title we can hear the static aspect. The next chapter, chapter 5, is called the dynamic aspect of law. So Kelsen makes this distinction between static and dynamic. We'll talk more about dynamic in the next video. The static aspect is, Kelsen also calls this law at rest, not moving. What this focuses on is how human behavior creates and affects norms, whereas the dynamic aspect is the opposite way, how norms affect human behavior. Kelsen makes some very big, very important, and I think some quite surprising points in this chapter, and let's dig into them. So we already know that law is a normative order that states when coercion should be applied. And in the beginning of this chapter, Kelsen breaks down like kind of branching distinctions, different types of coercion. The first distinction he makes is between sanctions and other types of coercion. Sanction mainly means imprisonment. Other coercion means, for example, internment, destruction of property. Those are the examples he gives. They are ones that are not linked to the acts of a specific person. Maybe some of the lockdowns that we saw during COVID can be seen as this second type. But sanctions themselves also branch out. So under sanctions, we can have direct punishment or civil sanctions. So while civil sanctions or civil executions are aimed perhaps more at social order, punishment directly relating to a person, not assets or something more general. This kind of punishment, Kelsen also says, apart from retribution, their function is not entirely clear. So I think this is already a kind of an important political statement that he makes. You know, this idea that imprisonment, for example, can have other reasons behind it, like we hear, like rehabilitation or something like that. Kelsen doesn't buy that. He says it seems that most coercion that goes into sanction, that goes into punishment, is clearly mostly there just for revenge. The important point he raises also in terms of sanction is that sanctions come into play not as a negation of law. He says that we commonly say someone is being punished because they broke the law. He says this is just a habit of speech. The law cannot be broken. It is exactly when the law is broken that the law actually comes into play. The law exists before the delict, and the delict doesn't break it. The delict activates it. He then moves on to talk about obligations, legal obligations, and says a few very interesting things regarding this. He says an obligation is just the opposite expression of a norm that already exists, right? So the norm says, well, you should do A, and now you have an obligation to do A. Because it's Kelsen, he makes a point expressly to say that this is not the same as the Kantian moral obligation. It's not Kantian and it's not moral. It's a purely legal obligation. Because, importantly, the obligation that exists is not for the legal subject to act in a certain way. The obligation is that if he does not act in a way, the normative aspect of the law, the ought to coerce, the ought to punishment, is activated. That is where the obligation lies. The obligation is, in a certain sense, on the law, not on the acting subject. He only has the potential to activate the law's normative obligation. He's not strictly under any obligation himself. He is, in fact, a free person. He can do what he wants. It is through his freedom that the law is activated or not. So we can never say that a person should do something legally. We can only say a person can do whatever they want, but if they do X, the law ought to respond in this way. And I think the first question that should come up with us when we talk about obligations first here, right, is necessarily then what about rights? We talk about legal rights way more than we do about obligations. So what does this understanding of obligations imply for legal rights? And Kelsen says that we should not think of rights as something that we possess, but that it's rather a reflection of the obligations that others have toward us, right? So we shouldn't think of rights as something that is inherent to us, that we possess, but rather that it's a reflection of the obligations that surround us, and not the obligation of other people, but the obligation of the law towards the behavior of people towards us. So, for example, today we often discuss or debate the potential for animals or natural phenomena, such as the Amazon, to be the bearer of rights. So for Kelsen, this would not be possible. Any rights that an animal or a forest can have is only a different way of saying what it really is, which is the law's obligation to punish those who act towards those animals or those forests in a certain way. So he gets rid of this problem of legal subjects and objects, because even a human being who has rights is not a subject, he's an object. So humans are objects, animals are objects, forests are objects, in terms of the obligations of the law to punish those that harm those objects. So I think this has a bit of transformative potential, right? Because what Kelsen already does here is put human rights and animal rights and the rights of nature on a theoretically equal platform, right? We don't have to make any great imaginative leap to apply the same rights to a human object or a so-called natural object. I'm saying so-called because, of course, humans are also natural. And for this reason, he also says expressly that the jus in personam and the jus ad rem distinction between humans and objects is a false one, legally, theoretically speaking. Any right, whether it be in a thing or a person, again, is just the reflection of a series of obligations. And here Kelsen's socialist sympathies come out. He says that this distinction between persons and objects, property, was made in the first place in order to protect a regime of private property, and that stressing a property holder's rights over his property rather than focusing, as he does, on the obligations of others to respect that property is an ideological move to make private property seem natural. So we have a powerful critique of private property from Kelsen here. He clearly says that it's a conscious ideological move made contingently in legal history or political history. He also takes it further to political rights in general, and he defines political rights as the right of people to have a say or an influence on the state and the legal order, the power of people to change that. And mainly this happens by instituting procedures through which laws can be validly amended or changed. And that the purpose of a constitution and a Bill of Rights is merely, if we can say merely, but is there only to make the amendment of those rights, obligations, procedurally more difficult. Doesn't make it impossible. We all know constitutions can be amended. So that's the purpose of enshrining something in the Constitution. Despite the language that says, perhaps in some constitutions, that this is eternal and the rights of man, natural, inborn rights, it's mainly a procedural matter, making the procedure tighter. Because of this view of rights and obligations, Kelsen also gets rid of the distinction between a person's capacity to act and legal capacity. So capacity to act, think of the acts that a person can do to commit a crime, and then legal capacity, entering into a contract or getting married, something like that. And we can think of several examples where a person would have one of those categories at their disposal, but not the other. It also means that obligations and legal relations, such as a contract or a marriage, is not, from a legal perspective, it's not a relationship between two persons, but a relationship between two reciprocal norms. This is all that the legal system can see. If I break my contract or I follow the contract, I'm acting in accordance to a norm that we set up. I'm not doing anything to the other contracting party. I think this closed system autopoietic view is quite interesting. He says that, we think of this as social relations, and from another point of observation, surely they are. But from the legal system's perspective, what the legal system sees is a relation between norms. It's not a social reality, it's a legal reality that we're dealing with, or that the law deals with. It is an entire world encapsulated and created and communicated by the law, about the law, to the law. And the legal subject is therefore only those who are able to use general norms to create personal norms for them, or specific norms for them, such as a contract, and who can activate sanctions by failing to fulfill their obligations. And for the law, this is all a person is: the bearer of obligations and someone who can create more obligations. Kelsen says that it's a distinctly ideological move to put the person outside or even above the legal system through talking of rights. Because what does that do? He comes back to the point of private property, that you are a person above the law who has rights, property rights, that this is natural, transcendental, outside of the law, outside of time, outside of society. It's not. It's all inside of society. It's an ideological move, rights. It's only obligations. He says that even the person is not a natural thing, but is something created by law. A person is only this kind of nexus, this bundle of obligations. That is what a person is. It's an entirely socially constructed concept from the perspective of the legal system. So Kelsen concludes this chapter by saying that the pure theory of law is a theory of objective law, of legal objects, not of legal subjects. The idea of legal subjects is something that comes from Roman law, but does not belong in a modern theory. The pure theory looks only at legal obligations within their totality, as a system. Interestingly, for later, he says that law is an organism, which means it's an order, it's a structure, which deals with problems of order and structure. Legal problems are problems of order, not of ethics, not of morality. So that wraps us up for chapter 4, the static aspect of law, and in 2 weeks we'll have chapter 5, the dynamic aspect of law. Until then, have a good time. Welcome back to the reading series. We're doing chapter 5 of A Pure Theory of Law, the dynamic aspect of law. This is by far, I think, the longest chapter in the book, and as such it's quite dense. But it's also important because this is the chapter where Kelsen speaks the most about the Grundnorm, or the basic norm, which is the idea that he's most famous for. So there are a lot of details going on in this chapter, but I want to focus it specifically on that, as that is what is most well known. So the question for the Grundnorm, the basic norm, is first, where does a normative order, where does it find its unity? How can we say that a body of norms fall together within one system, one coherent whole? And as you can guess, it's the basic norm or the Grundnorm that ties it all together, that unifies the system. So the basic norm is what unifies a normative system. But in order to do so, it has to be valid. So why is it valid? Because whenever we talk about the validity of a norm or ask about the validity of a norm, we always do it with reference to another norm. We can always go hierarchically one up, one up, one up. But at some point we can't do that anymore, right? At some point we have to stop. And it is the basic norm, which is the one that allows us to stop. So how do we find this basic norm? Kelsen brings back this distinction between the static and the dynamic aspect of law. A static version of a basic norm would be to try and find something through reason. So, for example, that we should live in harmony with nature, or through justice, or something like that. So that the basic norm is a product of knowledge or reason. But Kelsen rejects this idea. We cannot reason out what a basic norm is. It's not a product of reason. Rather, a basic norm has, in his language, a dynamic aspect. It means that it's a norm that exists only because it has norm-creating authority. And this is not a reasoned basis, but it's an act of will. Remember, we said that a basic norm always has to be presupposed. It's a sort of a fiction. As an act of will, it's not something that we can find through reason. It's just a moment. It's a fiat. It's the moment, do this because Father says so. So a basic norm is the starting point that sets in motion a procedure that can run for centuries, where norms continue to be created. And the end point of this procedure is coercion. And importantly, this would not be a positivist account if I didn't mention this, but the basic norm is never a transcendental justification. It's an immanent act originating in society, although perhaps fictionalized or presupposed. It's a moment in society where the major premise of a norm, of that norm, is not questioned. And then Kelsen goes on to do thought experiments on the basic norm in different directions. So he asks, what happens in the case of a coup or a big change of government, a revolution? He says that the Grundnorm doesn't change in that case. It remains valid. So perhaps the reason for the validity has changed. Think about the French Revolution. The people deciding on the norms have changed a lot. That reason behind the Grundnorm has changed, but the Grundnorm still remains there. It still rests on an act of effective coercion, effective violence. And this is kind of the test for a basic norm. Is it effective? As long as a legal order in its whole remains effective within a society, we can presuppose the basic norm, the Grundnorm, as being valid. So when no one follows your laws anymore, when it becomes mere words on paper, then the Grundnorm itself kind of dissolves away. So this distinction between effectivity and validity remain important. He says that we cannot conflate them 100%. It's not the same thing. But without effectivity, without actual following of your norms, the validity of your legal order becomes questionable. But they're not exactly the same thing. And in this sense, you often hear people say something like a constitution is the basic norm. But Kelsen disagrees with this. He finds the basic norm rather in custom than in a constitution. We had valid legal orders. Whichever country you're in, there were probably quite a few constitutions already, and people were following the law before the current constitution and the one before that. So constitutions themselves are not necessarily the basic norm. There's usually a custom that came well before that. In the rest of the chapter, Kelsen talks a lot about conflict of norms and the hierarchy of norms. And he makes the claim that laws or norms cannot contradict each other. Contradiction is a logical state, or contradiction is a logical assertion. Laws themselves cannot contradict each other. Two contradictory or seemingly contradictory norms are either valid or invalid in relation to one another. He says that true or false, I think we saw that in chapter 1 already, true or false is not a criteria by which we can measure norms. We can only measure norms by valid or invalid. And thus we don't have a problem if two norms contradict each other. We have a few rules for that too. For example, a later norm trumps an earlier norm, or norms are in a hierarchical relationship to each other, and the higher one in the hierarchy trumps the lower one. This doesn't mean that the lower one or the earlier one is false or contradictory. It's just that it's valid by itself, but the later norm or the higher norm can make that one invalid. And we find this hierarchy in norms because we use norms to make norms. Communication makes communication. Norms make norms. It's a kind of poetic statement, although Kelsen wouldn't have known that. And he also says for this reason that we don't have gaps in the law. The law is just the law. If we say that the law doesn't cover this situation, it's not a gap in the law. He says that is already a social or a political or a moral judgment that we make. The law, from its own perspective, doesn't have gaps. We might feel a political need to regulate something new that has arisen, and then we make laws, but that is a political need. It's not a legal need. The legal system itself is never... There are never holes in the legal system from the point of view of the legal system, maybe from the view of politics. So we saw that it's not really a problem when norms clash or contradict. That's not really a problem. But what is possible are invalid norms. And Kelsen names a few examples of this. He says that if we have a clash of norms, if a lower one clashes with a higher one, we can say that that lower one was perhaps never valid. So in that sense, we don't have a clash because the lower one was never valid to begin with. So this Grundnorm kind of spreads its way down through the legal order, down to the lowest level. So even judges, when they make decisions, that's also an act of norm creation, whether it's talking about the particular or the general norm. It's still the judge creates a norm in that instance by drawing from the Grundnorm. When we make a contract that binds us, we make a new norm between me and the other contracting party. That is also a norm creation relying on the basic norm, because that contract can become the basis, if it's not fulfilled, for a sanction. In a certain sense, whenever we're dealing with each other legally, we're always drawing a little bit of authority or validity from the existing Grundnorm, even if it's found in custom. So in summary, we see that the Grundnorm, the basic norm, is a kind of a fictional presupposition of validity, perhaps coming through custom, and it's something that we don't remember. Maybe it's too long ago. Society has worked this way for very long. But the point is that it's effective. It does influence how humans act. It changes or structures our decision-making paradigm. And it does this by hierarchizing the normative order in which we find ourselves. And we're always constantly borrowing a little bit from that basic norm in our dealings with one another. So that's it for chapter 5. Next episode, we'll be talking about chapter 6, Law and the State, which you can guess is important for this hierarchy, for the coercion, and, can I say, the mediator between the basic norm and the general population. Also from here, the chapters get shorter, so things are, I think we're over the peak of this mountain, and it's going to be downhill from here. But thank you very much, and see you next time. Welcome to the Hans Kelsen reading series. This is Dr. Nico Beitendach. Before we delve into chapter 6 of A Pure Theory of Law by Hans Kelsen, I just want to mention that I just published my first book, and a bit of shameless self-promotion. The link to the book is in the description for the video or for the podcast episode. It's open access, so you can get the PDF for free if you follow the link. It would mean a lot to me if you check that out, if you download the book. And also, please don't forget to subscribe or like or comment. It really helps the channel and helps grow the conversation that we're trying to have around these works. Anyway, enough of that. Let's get into chapter 6 of Kelsen's A Pure Theory of Law. And this chapter is titled Law in the State. I think this is not such a long, but a very crucial chapter in a pure theory of law. There are quite a lot of, I think, quite important insights that Kelsen shares here that's part of his theory, and I think they're important. A big part of this chapter is taking on the legal state, or the Rechtsstaat. And Kelsen goes through some effort to try and dispel many of the assumptions that this conception of the law and state has. Also, it being probably the prevailing theory in, let's say, Western European or Northern European thinking about the law and the state. So he goes quite at length to dispel many of the assumptions of the legal state. And I think quite a few surprising things come up in this chapter. A big part of this chapter is Kelsen raising two distinctions, kind of traditional distinctions that we make in legal and state theory, and then saying how the pure theory undermines those two assumptions and why they are paradoxical and thus untenable for Kelsen's scientific approach. The first thing that he raises and that he tries to unfold is the public and private law distinction, which we'll deal with first. And the second thing is this distinction between the state and law, the political system and the legal system. And Kelsen also has a lot to say about that, as we will see. So before we begin, Kelsen reminds us that he's trying to further a dynamic theory of law. Thus, not a theory of law referring to its creation, but to its results, its validity at the end of the day. So the first of these distinctions, this one between public and private, Kelsen has a problem with that. Now, he says that this distinction is usually described, as you will probably know, the public law being a kind of a vertical relationship, a hierarchical relationship of the state and its subjects, whereas private law is horizontal, it's inter-subject. It's a more equal relationship that governs the law and how norms are created. And he says there's an assumption lying in this that private law is kind of only law. It is contract or agreement. It is when two equal parties bind themselves and create a norm between them. Whereas public law, it's law plus power. There's something extra coming from the state down. There's not so much consensuality involved because there's an element of power. It rests on the state's power to command its subjects, and in the sense, the legal subject does not participate in the norm creation between him and the state and the public. And therefore we can say that the difference between private and public law is how a norm is created, through consensus or agreement or through command. But Kelsen says this is an ideological construct. Firstly, the pure theory doesn't want to divide the law up, but wants to see it as a whole, as a unity that is internally coherent. And in this sense, even private law norms, even agreement, has something of the public inherent to it. Even contract is in some way connected to the law of the state. It's not ever a purely horizontal legal relationship. Thus, this public-private distinction is an ideological one, and untenable for Kelsen. He says this ideology functions in two directions. On the one hand, for the state, for public law, it allows for a certain amount of power, as we said, for the state. It secures the state a degree of freedom, a freedom to make an exception, a freedom to make commands. We can think of the state of exception in, Carl Schmitt or Agamben. Of course, Kelsen also had his famous debate with Carl Schmitt, but, nevertheless, the point is that this idea of public law reserves a degree of autonomy for the state to do what it wants, not to follow the law strictly, to politicize what should be legal. On the other hand, what this distinction also does ideologically is with private law, saying that the private law is this completely free sphere of action where equal, free legal subjects get to bargain on an equal footing. And he says that's obviously not true. It depoliticizes private law. Think about contract, think about labor law, property law. It's rarely an equal relationship, even in private law. Kelsen explicitly refers to capitalism and says that under capitalism, it's very unlikely that two private parties are ever on an equal footing. Remember, we said property, labor law. So this is the first distinction that Kelsen wants to get rid of, this public-private distinction, for the reasons we mentioned. The second distinction, kind of classical distinction that he raises, that he says is common and should be dealt with, is the separation between law and the state. So first he gives an account of the kind of traditional view of this distinction, much as he did with the public-private distinction. So he says the story of the state, especially the legal state, the Rechtsstaat, is kind of a funny one and a contradictory one. So what is the story? He says that we have this kind of narrative or meta-narrative that the state precedes the law, then creates it, and then after that somehow subjects itself to this thing it just created. Meaning practically that the state makes itself subject to rights and obligations as it does for its subjects. This is the typical story. And this story is too weird for Kelsen. There's too much of a contradiction in this. What is the state? Is it somehow this kind of meta body, organization, society that can create law and then subject itself to it after that? That doesn't make sense to Kelsen. Because he says this is pure ideology and it serves an ideological function. It's not a correct or scientific description. And what is the function of this ideology? The first part of that is that the state has to show that it is somehow separate from the legal order. There's politics or the state and there's law, in order to justify both itself and the legal system. So there's something about self-justification or legitimacy at play here. And again, there's also an important function that it plays for law ideologically, namely that the law has to present itself as something being separate from power. It's not politics, it's cold, reasonable law. And there's another contradiction in this. We just spoke of the state of exception. So the state is somehow a subject to the law that it created itself, but also when it wants to, it can enter into the exception, the state of exception. This ideology lets the state have it both ways, right? It's logically contradictory. And Kelsen says this contradiction is able to exist quite easily. The words he uses is, it never causes any serious embarrassment for the state or for state theory. Why? Because it's never meant to be a scientific description. It is an ideological description, ideological construct, and thus, he says, never meant to truly explain something. It's not meant to create knowledge. It's only there to justify, to underline, to strengthen the state's authority. So this is the ideology of the state law distinction that Kelsen criticizes. So what does he say is the true relationship? He says, at its core, the state is a coercive power. It uses power to coerce coercive order. Remember in the previous chapters, we spoke a lot about coercive orders. The second point, talking about the modern state, is that it's centralized. And then he goes on a bit to define what constitutes the modern state as opposed to older pre-state polities or societies. And on the other hand, he also contrasts this with public international law. So he says that the modern state is firstly a centralized coercive order. In older societies, this was not as centralized. In public international law, it's obviously not centralized at all. Therefore, the state is a special modern construction, and it's defined. And he gives quite a classical definition of consisting of quite traditional elements of what consists of a state. Apart from its decentralization, it's the population, its territory, its power, as he calls it. Effective government would be perhaps a more standard way of describing it, but I think he means basically the same thing there. And then he goes on to discuss each of these three elements of the state. So he says, firstly, what is the people, the population of a modern state? How do we understand that? And he says, kind of nationalistic descriptions that we are used to. And I want to say it's a kind of a modern thing, but probably in so-called postmodernity, we're seeing this kind of argument come back with a lot of force. He says that we cannot describe or define the population of a state through something like ethnicity, language, race, the German idea of folk, the people. He says that this also just contains too many exceptions to make sense of. There's nothing like a national feeling that makes me South African or Austrian or French or whatever. He says a population of a state has to be defined quite simply as that collection of people that fall under the same normative coercive order. These are the subjects of that order. What language they speak, what religious belief they had, what ethnicity they are, their cultural history is not useful for us. The point is, whoever falls under the coercive order are subjects of the same state. Purely legal definition of population. The next element is territory. So he says, obviously, it has to be limited spatially, and this is defined quite easily, not with reference to borders or boundaries as we might usually do. Kelsen says this is the spatial area in which this legal coercive order of the state is valid, where they are able to enforce and apply it. So it's a pure kind of empirical question of validity for him. It's not necessarily something to be found on a map. He also kind of mentions that what people often forget is that states are obviously spatially limited, but also temporally limited. You know, no state lasts forever. Most of them have I think in modernity we can find quite specific start dates for most of the modern states. I think it's also a public holiday for most countries when they gain independence or something like that, the day of revolution, whatever the anniversary of that. And he says, obviously, all states must come to an end eventually too. So just as an interesting part, he says, you know, there's also a temporal limit to states, but we don't often talk about that. Then the final third element of a state, it's power. So this is the power to make its order valid, the validity of the normative order, right? And he says this is also found in quite literal material things. You know, he talks about prisons, armies, policemen, guns, weapons. This is the power of this state, of this coercive order, to enforce its norms. I think today we talk about something more like effective governance. For Kelsen, it's, are you applying norms that have validity? Are they being followed? And how do you follow them through coercion? How do you do that through these material requirements, all quite violent, naturally. Violent means of getting validity for your norms, coercion. You know, there's quite a bit of a like proto-Foucauldian element here. So that's the definition of the modern state. And he says legally it shares a lot of similarities with other juristic persons like corporations, in the sense that it's a kind of a fiction, right? Made up of human beings acting, many human beings acting in different ways, and that their acts are attributed not to themselves, but to this juristic fiction, this juristic person, and that the unity of all these millions of actors and actions are observed by us. We impute the actions of individual men or women to this idea that we have of the state, much like we do with a corporation, as we saw in previous chapters. So the state is firstly a kind of a mental construct to unify and attribute a vast collection of human action and activity. And then Kelsen also says, in a certain sense, you know, we shouldn't talk of the legal state or the Rechtsstaat, but that a lot of what we imagine is the state, a lot of what it's doing is administrative, not legal necessarily. So in a certain sense, we're better off talking about the administrative state rather than the legal state. Even in a democracy, attribution does a lot of work because, you know, we have this fiction of what this guy is doing in this office is not him, it's the state doing that. How do we explain that? He says in a democracy, a concept like representation, also a kind of fiction, right, is used to justify this attribution. He's doing it because he's representing all of us. I have to go to work today. I can't be focused on the minutiae of running our state. Therefore, I ask someone to represent me or my community in doing that. This is a kind of attributive fiction that is at work. Yes, in democracies, you could also say in autocratic or fascist countries, it's also the leader is often described as the embodiment or the representative of the entire population, even though he acts, with a lot of agency, with a lot of freedom to do what he wants. He's representing everyone's interest in doing that. And this is also why it's difficult for Kelsen to talk about the self-regulation of the state. Remember, the state submitting itself to its own laws. The legal state. Because Kelsen says laws are just often administrative actions taken by individuals or a small group of individual men or women that we fictionally attribute to the state. And then later, if the state submits itself to this law, it's again the actions of a group of people. And then we attribute their actions to the state. And this first part gets applied to the second part, and rights and obligations occur, are manifested. And this is a very complex network of individual actions and attributions. And we are only imposing a unity on it through our minds, calling it the state, and the state is submitting itself. It's not literally the case. The state is not this super organ that can do that. And that's why he said the Rechtsstaat concept doesn't refer really to him, to a state that submits itself to law, because it's not completely possible. He says what legal state, Rechtsstaat, really means. It's kind of a vague reference to a country that's democratic. And we can plausibly say that the laws or the norms of the existing coercive order are created through democratic representation. He says that's what it really means. So obviously Kelsen wants to get rid of this distinction between law and the state. He says it's an ideological fiction. It's not scientifically or empirically true. He says the state itself is nothing more and nothing less than this coercive order, coercive normative order, and that the state is the juristic personification, like a company, of this order. So in other words, the state and the law is the same. We cannot separate it. It's literally one and the same thing. The law is not separate. It is a coercive order that we call the state. And on the other side, the state is not governed by law. The state is the law. The community, as we saw, the population element, the territory element, the people in their unity is defined and created by the law. It's constituted by the law, and thus constitutes the state. It's all one thing. And at this point, he equates any idea of a Rechtsstaat to natural law. He says this is some weird transcendent appeal to talk of a Rechtsstaat. It's not true. So in summary, Kelsen criticizes the legal state on two important counts here. The first is this public-private distinction, where he shows that it's an ideological distinction that serves to hide power relations, or in the case of public law, to justify that power relation. And that it's purely ideological, and strictly speaking, we have to get rid of that distinction. On the other hand, this distinction between state and law, again, it's much like public and private, this distinction between law and power, that this is also a false distinction, and that we can't speak of law and the state, but the law is the state and the state is law. And he caps this off with the final sentence, which I think is quite interesting, which deserves reading in its entirety. He says, "This critical abolition of the dualism of state and law also represents the most radical annihilation of one of the most effective ideologies of legitimation. Hence, the passionate resistance with which traditional theory of law and state opposes the doctrine of the identity of the state and law as founded by the pure theory of law." So he says, this is the true definition or relationship between law and state, public and private. And he thinks it's a very incisive critique, cutting critique. And I guess from that sentence, we can assume that he got criticized a lot for it. And he says that those who criticized him are trying to defend some kind of ideology that's untenable. So that's it for this week. Now we only have, I think, 2 chapters left, one on international law and one on interpretation. Then we're done. And then we're finishing with the interview with our Kelsen expert, the world Kelsen expert, Lars Vinks. I'm looking forward to that. So we're almost finished. Thank you very much, and see you again soon. Bye-bye. Welcome to the Undisciplined reading series. It's me, Nico Beitendach, and we're heading towards the end of Kelsen's A Pure Theory of Law. Today we're doing chapter 7. Before we start, the usual kind of announcements. First, please like and share these videos if you can to people you think might be interested. It would really help. I really appreciate that. And secondly, like I said in the previous video, my book just came out. It deals a lot with the questions that we're talking about today, international law and foundational aspects of international law. So if you're interested in this video, you'll probably be interested in that. The link to that, it's open access, free download, is in the description. So having that out of the way, let's dig into Kelsen. As we said, it's chapter 7, the state and international law. So some of these questions that Kelsen deals with in this chapter, think about it's, the pre and post World War II years. These are quite foundational questions for the new kind of international law that was coming up. And Kelsen was very interested in those. He also wrote a lot specifically on international outside of the pure theory. He has whole monographs dedicated to international law, and perhaps some of these questions might seem a bit old-fashioned by now, like we've resolved them, which is true to a large extent, but Jawbreaker says survival never goes out of style, and I think a lot of these foundational questions also never go out of style. So in this chapter, I think Kelsen tries to do two main important things here. The first is to establish or to answer the question of whether international law is law at all. Does that fit within his theory of law that he spent the previous 6 chapters delineating? Does international law fit within that? That's the one question. And then secondly, which follows from that if it is, how do we reconcile that with national or domestic legal systems? What is their relationship inside of the pure theory? So on to the first question. Is international law, public international law, is it law? Because we saw earlier, Kelsen sometimes has these quick asides where he says that public international law is perhaps still more primitive than national legal systems. It's not as developed yet. So the question is, given the criteria that he laid out for national legal systems, does international law qualify? The short answer is yes. But how does he justify this? So let's go back to Kelsen's definition of what a legal system is, right? So it's a coercive normative order that backs itself up through sanction. Does international law fit this definition? He says, well, okay, obviously it's a normative order. There are international legal norms. The second question is, are there sanctions, coercive sanctions? And he says yes. Namely, at the time that he was writing this, keep in mind, the sanction of international law was reprisals and war. These are clearly coercive, and they are employed as a sanction to a norm that has been broken. He makes this distinction between reprisal and war because a reprisal is something where the use of force is not necessarily present. And he says that also, kind of on the other hand, war is not just pure power or the law of the jungle. Law qualifies as a legal sanction. Why? He mentions the League of Nations and then the Kellogg-Briand Pact and eventually the United Nations Charter, which puts limits on the use of force on war. And he says, so it gives conditions for when war is legitimate, and that makes it so that law takes on the character not of Hobbesian survival of the fittest, but rather it has to be a response to a norm being broken. So war and reprisals take on a punitive character through the League of Nations, Kellogg-Briand, the United Nations Charter. War is not just a fight, it's a punishment, it's a sanction. And he says, okay, but then the second question is, it's a normative order that regulates human behavior. And now we could say that, okay, but public international law is aimed at states as subjects, not humans. And then he says, okay, but this is also not a problem. This works because at the end of the day, what international law does is regulate the actions of humans. The difference is that the real actions of humans are not attributed to themselves. Remember right in the beginning how important attribution is in the legal system and understanding law as a science. But it's human action that is attributed to a state rather than individual. It doesn't matter who the particular individual is. He's acting on behalf of a state, and his actions are regulated by this normative order. So in a sense, it's almost like a company in a national legal system. It's still human actions being regulated. Doesn't matter whether it's attributed to them in their personal capacity or to the state. We're still dealing with human actions at the end of the day. So Kelsen describes this in inverted commas as a kind of a collective liability under which states are the subjects of international law through the actions of individuals. So we see that for Kelsen, all the elements of his definition in the pure theory, he is able to confirm that public international law is law. And he also says that this is the case at the time that he's writing, but that international law is moving. It's very decentralized now compared to national legal systems, which are very centralized, as we said. But he believes that international law is moving towards greater and greater centralization. You know, he talks about world law or a world government in one or two points. I get the feeling there's a teleological inevitability for Kelsen in this. This is perhaps also a bit of a sign of his time. The final question on this, whether international law is law under the pure theory, would bring us back to the Grundnorm, the basic norm. And where do we find that in international law? He starts with a very hierarchical breakdown of the sources of international law. He gives 3 levels. He says custom, then treaties, and then the decisions of courts and international organs or international organizations. And he says that if the basic norm is to be found anywhere, it can be found in international customary law. He also does this for national law. Remember, he says that, okay, the basic norm has to be presupposed, and it's probably in long forgotten custom rather than a constitution. So given that we've established international law as law in the scientific definition, the obvious next question becomes, what is the relationship of international law with national law? He says we can understand this in 2 ways. There are 2 possible theoretical constructions: a pluralistic notion and a monistic notion of this relationship. He prefers the monistic notion. But first, let's debunk the pluralistic understanding of the relationship between international and national law. So the pluralistic notion says that international law and national law are 2 separate legal orders, that they are not in sync with each other and that they can conflict. Kelsen says this critique of conflict between international and national law does not mean that they are 2 separate orders. It's not a good enough reason. He says because national orders can also have internal conflicts, and it doesn't pose a problem for the unity of the national legal system. So the conflict between international law and national law also should not pose a problem for the unity of this. He also takes on the criticism that international law norms are often broken. He says this is also not a problem. We saw in an earlier chapter that for Kelsen, the breaking of a norm does not negate the validity of that norm. If it happens too much, yes, perhaps. But in principle, violating a norm does not negate the existence of that legal order. In fact, that is what activates the legal system to impose a consequence or a sanction. In short, Kelsen wants to get rid of the pluralistic conception, namely that international law and national law are separate orders. He says we have to follow a monistic model, which says that international and the various national laws all form part of a single unified order. Now again, within the monistic understanding, there's two theoretical constructions that are possible. The one is a hierarchic construction, the other one is a coordinated construction. The hierarchic construction places emphasis on international, that international law is above national law. The coordinated construction or coordination construction prefers to put emphasis on national law, the primacy there, and that national and international law coordinate with one another, but the national law is the most central one, the primary one. Kelsen does not completely express a preference for either of these two constructions. He says both are scientifically plausible or valid ways. The point is that both are monistic. It sees them as a unity, and where you prefer to put the emphasis does not change that fact. Although there are some differences in the details depending on which side you emphasize. So he goes on to explain this. He says, what happens when you put national law as the more important part of the legal order over international law? This means that public international law is valid to the extent that a state in its own legal order recognizes international law. So it places an emphasis on sovereignty of the state. He says, but if you think about it this way, so then international law is in the end only a part of national law. Once the state accepts it, then it becomes part of its own normative order. That's fine. The two systems are still coordinated, although they have their limits of where the one starts and the other one ends, but it's not a problem for the unity. The other construction of a monistic order is putting the primacy on public international law, which means that the authority or sovereignty of the national legal order is delegated to it by public international law. In this case, being sovereign merely means being part of the family of the international order. And then he says there's a common criticism of this idea is that states predate public international law. I would add that defining a state is already not a simple matter. It's debatable to what extent we can say that. There's a good argument to be made that states are very new. But nevertheless, Kelsen does not see a problem with this criticism. He says that this doesn't matter because we should not confuse temporality with logic. He says that the fact that states are temporarily prior to international law does not mean that they are conceptually prior to international law. Even though international law came later, we can conceptually or logically place it prior to the state. He says, for that matter, the family unit is older than the state, but we don't regard the family unit as having somehow more legal sovereignty than the state does. So we have to think about it conceptually, not within time. So the point is, whichever construction you prefer, whether you prefer placing the priority on national law or whether you prefer placing it on public international law, both of these are monistic constructions, meaning that international and national law form part of a unified single legal order. And that in itself is good enough for Kelsen. Which one you choose is not so much a legal question as it is perhaps a political one. Both only give a different reason for why public international law is valid. It doesn't call into question the validity itself, only its justification. And both are plausible. And he ends the chapter by saying that, like we said, whichever one of these two constructions you prefer, it's more of a political choice or a philosophical choice than it is a legal scientific choice. What does he mean by that? He says each of them betray something of the person who chooses their worldview or world outlook. He says the first construction of placing primacy on national law has a more imperialistic tendency, where the one placing emphasis on international law has a more liberal pacifist tendency to it, although this is not per se. He goes further kind of philosophically, and he says that the difference is basically the one between a subjectivist worldview and an objectivist worldview. The national priority is subjectivist. It places you, the subject, or your state as a subject at the center of your worldview. The self is sovereign. And he says this is almost like a geocentric conception of the world, where the earth is the center of the universe. So by analogy, your state is the center of the world and you yourself are the center of your world. The international law side is objectivist. It kind of sees the world in its bigger picture from the outside looking in. He says this is more like a Copernican worldview, where, the earth is decentered and yourself and your state is decentered. You're only part of the world, one piece of the puzzle of the bigger picture, not in the center. You yourself are not in the center. You are just one thing among many moving within this bigger picture of the world. And I quite like Kelsen's kind of philosophy of science here. He says, both are correct interpretations. You cannot say either is empirically wrong. Both are valid. The point is, where are you observing from? Are you observing from, kind of like your own skull outwards? Or are you observing from a sort of a bird's eye view, looking down at everything? This is a choice. The one is not more true than the other. And anyway, where we choose to observe from is anyway a choice, perhaps a political choice or a personal choice. It's not a legal choice, and it's not a scientific choice. The final decision of where we decide to observe from our own skull or from floating in space, cannot be a legal choice. There's no legal reason for choosing one perspective or the other. It has to be a kind of a philosophical or a political choice. The law cannot decide. Whichever one you choose, it leads to a monistic, unified understanding of the relationship between international law and national law. And the point is that, we talk about this legal system, that legal system, but at the end of the day, there is only the legal system. And the legal system can be used for conservative ends, it can be used for progressive ends, it can be self-centered and imperialist, it can be outward-looking and liberal. That's a political or philosophical choice. But thank you very much. That's Chapter 7 on the state and law and international law. In the next video, we will finish. It's the chapter on interpretation. It's a very short chapter. It's about 6 or 7 pages. So that video should be quite short. So I think I'm also going to use that video to kind of wrap up and give broader final thoughts on the whole book. So thank you very much. I hope you have a lovely week, and see you next time for the final one in our Kelsen series. Goodbye. Hello and welcome. This is Nico Beitenach, and we're on the last episode of our Kelsen reading series. Today we'll be doing the final chapter, chapter 8, on interpretation. And because it's kind of a short chapter, I thought that it would be a good time to also just do a kind of summary or final thoughts about Kelsen's A Pure Theory of Law. Then, of course, the current season of the reading series really ends with the next video, which is an interview with Lars Vinks, a Kelsen expert, to put it all together for us in a bigger context. So let's get to the final chapter of A Pure Theory of Law, interpretation. So to start with, Kelsen makes a distinction between two important sides of interpretation, the two contexts in which interpretation happens in the law. The first is by a law-applying organ, such as a court or perhaps a civil servant, who is interpreting the law with the intent of actually applying it, and his decision has legal effect. And on the other hand, legal interpretation as done by someone without this competence, so a legal scholar or a lawyer giving his opinion, or a layperson trying to find out what their legal position is. So you can guess that the more important of this in society is the first type, the interpretation by a law-applying person or organ. So the interpretation of a norm always takes place within the hierarchy of a bigger norm. The current norm is always somewhere below a bigger context or framework, which helps us interpret it. And interpretation is needed because this lower norm is, in some sense or another, a bit vague. This can be intentionally or unintentionally. Kelsen says if the lower norm is too strict, not vague enough, it doesn't leave enough freedom for the discretion of the law applying organ. We know that the law cannot hope to enumerate every single situation, and thus has to be a bit vague in order to be workable, and thus necessitates a level of interpretation when it's being applied. So that vagary that creates the need for legal interpretation can be intentional, but it can also be unintentional. So what the interpreter has to do in this case is, given the higher norm, Kelsen says, determine the frame in which the lower norm that is to be interpreted is moving inside of. So the frame that we choose determines the content that we give to the lower norm moving in here. So it's the frame that guides us. But then Kelsen becomes very clear. He says that there are many possible frames within which to interpret, and you have to choose one over others. And how you exercise this choice is an act of will. There is no necessarily correct frame. So what the pure theory can't do is it can't suggest or recommend the best frame within which to interpret. The interpreter has to choose that frame, because for a pure theory of law, all of these frames are equal. And the pure theory cannot decide on the correct frame, because choosing this frame, it's an act of will, meaning it's an extra legal consideration. It's a political decision, which frame you give preference to when interpreting a norm. So this frame can be a certain interest or certain values, whatever. You can hear from that that's already not a legal consideration, that's probably a political consideration. And thus, the pure theory cannot say what is a correct interpretation given a certain frame. It would be the same as to say that there's something like a correct statute. It doesn't matter, or you can't say that. You know, it's only, the question is only, is it legal or not whether it's correct or incorrect by an extra legal measurement. So interpretation always has the element of cognition, legal cognition, that is involved in interpreting the specific norm, but the frame that it happens in is an act of will. And when this process is complete by an organ with the mandate to do so, law is created. So that's the first type. This differs from the second type. We said perhaps the legal academic or the layperson trying to interpret. The big difference is their interpretation does not create law. It's not enforceable. It's just an opinion. So what the legal expert can do, or the layperson, is only to show different possible interpretations of a norm. And after these different possibilities have been laid out, that's all the legal scientist can do. Choosing one as preferable over others, again, is a political decision. So the legal scientist, legal academic, can stay within his sphere as long as he's laying out the different interpretations on the table. But as soon as he expresses a preference, it's an extra legal opinion that he's giving. To summarize, Kelsen writes, and I'm quoting directly, he says, "It is, from a scientific and hence objective point of view, inadmissible to proclaim solely correct an interpretation that from a subjectively political viewpoint is more desirable than another, logically equally possible interpretation. So we see that's it for Kelsen on interpretation. It's a very short chapter. Kelsen has also been criticized for taking such a hands-off approach on interpretation and not getting stuck into it, that he doesn't offer us much in the way of helping with interpretation. He kind of sidesteps the question by deferring to the difference between politics and law. But yes, that's what he does in this book, for better or for worse. So that's it for the pure theory of law. We made it all the way through, and I think it's a good time to wrap up and take some of the more prescient thoughts that we had in the reading of this book. I think there are three important themes for me that kept reappearing in the book that I would like to highlight to end off with, namely the idea of purity, the role of ideology in legal theory, and finally, the relationship between the law and the state. So let's start with the title of the book, the first theme, purity, and what this means for Kelsen. The term purity really cuts to almost every part of this book. And in understanding that, I think, is key. So I think what is important to always keep in mind when reading Kelsen in this book is that Kelsen is self-proclaimed a big Kantian. And it is from Kant that this idea of purity comes from, so powerfully for Kelsen. As we know, Kant was interested in pure reason. For Kant, purity means cognition without any outside influence, pure cognition. And this is the way that Kelsen wants to approach law. Also, in his critique of practical reason, Kant says that where he analyzes morals, Kant says that we cannot derive a moral law from the content of its prescriptions or of its norms. We can only divine these laws, these universal laws, from the form. And that is how Kant gets to the categorical imperative. It's a formal definition of morality, not a content-filled definition. In other words, Kant gives the test of the structure of a moral law. He doesn't give us the content of the moral laws. Now, of course, Kelsen tries to remove law and morals as much as possible, but it's a similar move. He defines law not by its content, but by its form. Remember, it's a valid order of norms backed up by coercion. What the content of the laws are is of secondary or of no importance to Kelsen. So this is how Kelsen approaches it. Law is fully in the phenomenal world, not the noumenal world. And he does this for good reason. He's trying to, if we remember the first chapters, he's trying to unburden his legal theory from at least two different approaches. The first is, of course, natural law theory. So he says natural law theory cannot give us form, it can only give us content. That's why we have to get away from that. On the other hand, he wants to get away from these kind of overly scientific, methodologically mixed approaches to law, found in realism or such, which he describes as a sociological or political methodology applied to law. And then that's fine, you can do that, but then it's not a legal theory. So legal theory has to fight on both sides between natural law and kind of sociological or political approaches. The pure theory is a purely legal approach. We also see Kant's influence in Kelsen through Kelsen's liberalism. We know he became increasingly interested in international law. The pure theory book has a chapter on international law, but after that book, after the German version, Kelsen already started writing more books on international law specifically. And in the pure theory, he talks of this kind of coming world state, perhaps. So, and we know that Kant was an important figure in the development of this cosmopolitan liberalism, this family of nations that Kelsen also subscribes to. So this Kantian purity thesis, I think, is one of the most vital contexts in which to read Kelsen, probably by his own admission in many parts. The second theme is that of ideology. And we saw that Kelsen often talks about ideology in different contexts in this book. And that one of the aims of the pure theory is to get rid of ideological thinking when we think about the law. For example, he says that property law and property relations is a product of ideology, capitalist ideology. He also says that separating the law and the state is a kind of an ideology that should get rid of, because the law and the state is the same thing. In the chapter on international law, he talks about the two ways to interpret or to understand international law and national law. And he also says these are open for ideological abuse. It's one possibility is that it can be used for empire or to justify empire. And even, as we saw now, in interpretation, whichever frame you choose is a political or ideological choice. And thus, Kelsen doesn't want to say which frame. The lawyer has to steer clear from ideology, or the legal scientist. And finally, the last theme is that between the law and the state. So as we know, he says that we can't separate them from one another at all, that the state is only a legal construct and not more than that. In a sense, this ties in, or this is consistent with what he says about persons, about corporations. He says even a human being, even a corporation, is nothing more than a bundle or a cluster of norms. Now, I mean, I think there's something to this idea. There's also some criticism we can have of that. One would be, of course, and I think Kelsen also talks about this in the book, in the sense of when he says that the object under scrutiny depends on the person doing the observing. You know, the object changes depending on who's observing it. And of course, then, if we observe the state from the point of view of law or legal theory, then the state looks like law. It looks just like a bundle of norms. a human being looks like a bundle of norms. The way a lawyer and a doctor looks at a person fundamentally changes the definition of a person for each of them, right? Same with the state. And Kelsen talks about why this ideology of how can the state be somehow above the law but also subject to the law. This, of course, is also a question of power. He criticizes the Rechtsstaat. For a state to present itself as a legal state is not a loss of its power to law. Practically speaking, it vastly increases the power of a state if it's able to legitimize itself through showing that it holds itself accountable to the people somehow. States are much more powerful because of that compared to earlier states, and if we think about the legitimacy. But yes, the state is this bundle of norms. It's something that Kelsen admits exists in the ideal world, not the real world. But nevertheless, those are my thoughts on the book. Of course, more, but we can keep discussing that. Thank you so much for sticking to the end with this. I really appreciate it. Next, we're going to read Heart, although I think I'm going to take a little break first before that and hopefully make better videos in terms of production quality. That's my hope. And please check out the interview with Lars Vinks coming after this video. And thank you very much. And I will see you again soon. Goodbye.